I'm informed there are some pieces that pertain to judiciary, so we are going to hear from Ledge Council about those pieces and see if there's any discussion. Of course it is.
So great, good to be back. Michelle Childs for the record, Office of Legislative Counsel, and joined by Jen Harvey, Office of Legislative Counsel. So I'm going to just start a little bit, and I think you're just taking a look at sections 1, 5, 6, and 11, 13. And we'll go through those with you, but I just wanted to kind of refresh your memory, as the senator mentioned to me earlier, because is this what we did a couple of years ago? And you are correct. And so in 2023, the legislature passed Act 13 and Act 14 with respect to legally protected healthcare. Remember, legally protected healthcare is in Title I, and it's defined as reproductive healthcare services and gender affirming care, healthcare. There's several places in law where it's the stated policy of Vermont to be protecting access to and provision of that type of healthcare in Vermont. Those two bills, you'll recall, there was one that lived primarily in the health and welfare committees that was around regulated professions and medical data, and then there was the other bill having to do with civil and criminal procedures that was in the judiciary. So that's why we both kind of work on the legal issue. So remember that one of the big things that came up in enacting those bills was the issue of interplay between the states in terms of recognizing the laws and judgments in other states. And so I just want to start out just kind of reminding folks about full faith and credit clause in the U.S. Constitution, and that generally there is common T, not common E, but common T between the states and recognizing the statutes, the public acts, and the judicial orders in other states. When it comes to court orders, there's very little room for a state to assert that there's a reason as to why they don't comply with the order. So generally, if it is a judicial order, you must comply with the judicial order. There's a few little exceptions around if the court didn't have proper jurisdiction, or the person did not have due process. But other than that, you have to follow the court orders. But when it comes to recognizing the laws of other states, there's more room for states if they have adopted a certain public policy that is contrary to the other states. Then Vermont can say, this other state's policy and laws are contrary to how we do things here, and we don't have to recognize them or apply them when there is a situation here in Vermont. And so that's kind of the underpinning of the shared laws, right? Vermont can only control what goes on in Vermont, right? We can't tell New Hampshire what to do. We can't tell the feds what to do, but we can control this. Legislature can adopt a law, say this is a state policy, and the state has chosen to protect either, seeking, providing, or facilitating someone getting legally protected healthcare. So section 1 is an amendment to the definition section of legally protected healthcare. You want to talk about it?
Sure. So this is adding a provision to the existing definition in Title I of legally protected healthcare activity to say that the protections that apply to people who engage in legally protected healthcare activity also apply to a person who has previously undertaken one or more acts or omissions while in another U.S. jurisdiction and then this is using some language that just repeats what's earlier in the definition, to aid or encourage or attempt to aid or encourage any person in the exercise and enjoyment or attempted exercise and enjoyment of rights to reproductive healthcare services or gender affirming healthcare services that would have been protected by the state if they had been undertaken in this state, provided that the acts or omissions were permissible under the laws of the jurisdiction in which the person was located at the time they were undertaken. Basically, it was allowed in the state where the person was when they were helping somebody or engaging or performing services related to reproductive health care or gender affirming care. If it was legal where they were and would have been legal if they were in Vermont, then if they come to Vermont, Vermont will protect them from adverse actions relating to their participation in the legally protected healthcare act.
So it was legal in state A. It's legal in Vermont. What do we need to say?
So again, so in New York, so if the provider engaged in conduct that was legal in New York, right? Again, New York can only control what's within the borders of New York, right? Once that person leaves the state, then they're susceptible to the other states' laws, right? So that person, let's say in the case of the New York provider, treating a patient that had been a patient theirs in New York, but was in Texas at the time, and they, prescribed medication or such, and then it was against Texas law. If Texas was going to go after that provider, but that provider was at home in New York and they provided that care, New York would protect them. But once they leave the jurisdiction of New York, they're subject to the laws of another state. The way that our current definition is set up is that it is focused on people who either provide the care in Vermont, obtain the care in Vermont, or they're helping someone obtain that care in Vermont. So that New York doctor doesn't have a nexus with Vermont, but if they were to travel here, so, there are neighbors, right? Somebody comes across the lake and goes to their friend's camp for the weekend. They would not be currently under the provisions of the law currently covered by Vermont law, because they didn't provide those services here. But New York law and Vermont law are very similar, and it was legal in New York and that conduct is legal in Vermont, then they would have that protection in Vermont. So if you have a situation where, let's say the New York doctor, let's say Texas has charged that doctor with a crime, they have issued a fugitive warrant. There's one circumstance, there's a provision, what we did in the Shield Law a few years ago, that says that in cases of extradition, we are not going to extradite someone to the demanding state unless that person is a fugitive from justice and was physically present in the demanding state at the time of the alleged offense, because that's like a space where states have some discretion about whether or not to comply with an extradition warrant. Generally, states are required to comply with extradition warrants, but if the person is not a fugitive, as in the sense that they have literally fled the demanding state, they committed the crime in the demanding state and fled the demanding state, but like the New York doctor was in New York when they provided the care. So if there was a warrant that was out, right, and so that, let's say the New York doctor comes over to Vermont and gets stopped for speeding or something like that, and they pull up and they see that there's a warrant for that, they would still get the protections in Vermont that they would get if they were in New York.
As long as this law is proposed.
Correct. Yes, if it was legal, if what they engaged in was legal in New York and protected in Vermont, and similarly would have been legal if they had engaged in that activity here, we're allowing them to have the same protections as if they were.
So basically it's getting if a third state is trying to get involved, it protects against that.
So I think, I'm pretty sure I understand, and I think I have sort of a simple way of framing it. And that is basically to say, if that third state was just waiting for the person to leave New York to actually grab them, this means that they would still be protected in Vermont. That would not be possible.
Correct.
Yeah.
No, it's not. So it's just providing reciprocity to the other states that have shield laws in terms of the protections, whether it's patient or provider or someone themselves.
Yes.
So the next section is section 5, option 5, then we talk about 6.
Page 10.
All right. Non-cooperation, I think y'all gonna be talking about this idea a little bit. So, there's a provision in Title 12 that was part of your, one of your shield bills in 2023 on non-cooperation. And essentially what it says is that, it's identifying the fact that, in several places you've said, this type of health care is protected in Vermont. It's the state policy. Therefore, if there is any action from outside of the state to infringe upon legally protected healthcare on the, infringe on the rights of somebody who's a provider or seeking care or facilitating someone getting the care, then the state's not going to devote any resources to helping. Doesn't mean they're going to interfere, doesn't mean, whatever, but they are not going to assist in another state's action of what's called like tortious interference with legally protected healthcare. You have some provisions in Title 12 around that. The state is not going to assist with that type of prosecution of the person. The change here that you see, other than changing from person to individual, is you'll see on line 13. There's the addition of federal. So when this issue was before the General Assembly in 2023, it was focused on interstate interaction. This is adding federal there. So again, if there were some type of circumstances where the federal administration was seeking to punish someone who is protected in Vermont for seeking or providing care, legally protected health care, then Vermont would not assist in those actions. So I also want to draw your attention to that there are exceptions there. The first one you see at the top of page 11 under subsection B. One is that if there's some type of investigation or proceeding where the conduct that's subject to potential liability under investigation would be subject to liability or investigation in Vermont, then that's not going to apply. So if it has, if there's something that, so it basically, it's like, it has to be clearly legal in Vermont, right? If there's a question as to that, then the state is not barred from participating in that. The second instance is if there's a court order, right? So like when I talked about before, when it comes to bulk and credit, and also looking at federal judicial orders, you have to comply with a court order. I mean, there's maybe options for appeal there, but you don't have the option of not complying with a court order. And so this is just tweaking the language a little bit. I think originally I had, because we were doing with the shield laws and some of the states were sharing language back and forth, and I had in there any action taken by judicial branch, judicial proceedings. And I think it's just clearer to say an order issued by a Vermont state court or a federal court. So if there's a federal court order that is saying that, the state has to provide information or cooperate with the feds in some circumstances, even if it would be in violation of our state law, you still have to comply with that.
So it isn't a governor's court order.
So on you're talking about the extradition issue. So for extradition, generally you have to comply with all of that, but there's a provision in the law that y'all passed in 2023 that says that you don't comply with a demand for extradition from the demanding state if it concerns legally protected health care and the person who is sought was not present in the demanding state at the time of the alleged offense.
But it is a court order. As judicial review, right?
But it's issued by the governor. It's not a court order. Section 6. Yeah, I just want to about right. So I just want to mention on 3. That's the language you might recall Bob, was that when you guys were working on it before, there was a question of, well, what if a law enforcement officer is looking at a warrant and, it's not apparent, like there's a process for being able to, kind of vet those and determine whether it's a valid warrant, but if they are acting on it, even if the basis is for legally protected healthcare and they would otherwise be protected and you wouldn't recognize the warrant, that's to just kind of address a situation that there's no liability on the part of like a law enforcement officer or state employee or somebody who is, basically, here's the information, I'm acting in this faith on the information that I have. Okay.
Section 6 amends 18 VSA section 1881. This is around some limitations on disclosure of protected health information. And this is building on some of the language that was done in the Act 2 years ago. So starts out with just some existing definitions, many of which all the federal law ones come from HIPAA. And under existing law, not changed in subsection B, a covered entity, which is an entity that is required, that is covered by HIPAA, that is required to comply with HIPAA, or their business associate is not allowed to disclose protected health information unless the disclosure is permitted under HIPAA. But HIPAA is a floor, not a ceiling. So in subsection C, we've added on some additional state level prohibitions on disclosure of protected health information. So notwithstanding any provision of subsection B to the contrary, in order to protect patients and providers who engage in legally protected healthcare activity and except as set forth in some exceptions in subdivision 2, a covered entity or business associate shall not disclose protected health information that is identifiable or susceptible to re-identification and related to legally protected healthcare activity. And first, to any government entity other than the state of Vermont or its political subdivisions or instrumentalities, if the covered entity or business associate has reason to believe the information will be used either to conduct a criminal, civil, administrative, or professional disciplinary investigation into any individual for the mere act of seeking, obtaining, providing, or facilitating a legally protected healthcare activity, or to impose liability or disciplinary action on them, again, for the mere act of seeking, obtaining, providing, or facilitating a legally protected healthcare activity, or to identify someone for any of those reasons, or for use in this is existing law, in a civil or criminal action, preliminary proceeding, or probate, legislative, or administrative proceeding. And then in existing law, it goes into unless. This is the same idea, but it's just restructured a bit because of some of the changes we made in the first subdivision. So now it's notwithstanding any provision of subdivision 1, to the contrary, disclosure is permitted of information, protected health information that is identifiable or susceptible to re-identification and related to legally protected healthcare activity if it meets any of these conditions. Under existing law and maintained here, the disclosure is authorized by the patient or their representative. Striking out the disclosure is specifically required by federal law, Vermont law, or rules adopted by the Vermont Supreme Court. Some of that will fall under some of these other exceptions. The disclosure is ordered by the court of competent jurisdiction. This is existing law pursuant to federal law, Vermont law, or rules adopted by the Vermont Supreme Court. So court ordered it must be disclosed. And then this clarifies that finding must only be made by a state court. Compelling disclosure must include the court's determination under existing law. It's that good cause exists to require disclosure. This would change that to say the information will not be used to impose criminal, civil, or administrative liability or professional disciplinary action on anyone based solely on the fact that they sought, obtained, provided, or facilitated a legally protected healthcare activity. The exception in subdivision, what would now be C, is mainly just some clarification that the disclosure would be made to, in this case, a business associate, not just any person designated by the covered entity or their business associate for use in defense against them against, in a legal proceeding or otherwise. Otherwise, no changes there. No changes to required disclosures to Vermont's Board of Medical Practice or Office of Professional Regulation if they're doing a bona fide investigation of a Vermont provider or of whether someone who is not licensed here engaged in unauthorized practice. Also, no changes in the next one, which is a disclosure to one of our regulatory bodies in connection with a bona fide investigation of a licensed healthcare facility in the state. Then a new exception for disclosure that is required in the ordinary course of business of Vermont's Medicaid program, subject to that non-cooperation provision that we looked at in the previous section. And then finally, there's some protection for the covered entity or business associate from any liability or disciplinary action for refusing to disclose protected health information in accordance with what is permitted or required in this section. Basically, just trying to make it harder for a covered entity or business associate in the state to be compelled to disclose protected health information related to legally protected healthcare activity.
And House Judiciary took a look at this section primarily just because it was talking about, disclosure specifically required by federal law. And there's a provision, they did make a small change to what came out of House Healthcare on subdivision C to B. And that's where there's a requirement that the disclosures were by a court of competent jurisdiction pursuant to federal law, Vermont law, or court rule. And the language originally said that an order compelling disclosure has to include the court's determination that the information will not be used to impose criminal, civil, or administrative liability or disciplinary action on any individual based solely on the fact that the person sought, obtained, provided, or facilitated legally protected healthcare activity. And because that said, any court that's doing that, the House Judiciary did a floor amendment on that and restricted it to a state court. So it's like compelling and saying that if the court is going to say you have to release this protected healthcare information pursuant to law, Vermont can't tell the federal court what it must include in its federal order. We can only do that with regard to the state court. So there was just that very small little technical tweak to that was clarifying that it's only state courts that would have that requirement to make that funding record.
Ready for section 13, which is unfortunately labeled as 11. That's why you said
Okay,
right.
right.
I was doing it.
I had it 13 first and then I was.
Yeah, when I was doing the markup version, a lot of changes, and I didn't know if you could update the section numbers, but it's right in the actual bill. So we're on page 25. Just labeled as 11 because section 13. And this has to do with the confidentiality of prescriber and pharmacist information on medications for legal protected healthcare activity. So in the bill, as it left the Senate, there was a requirement that if a prescriber requested, and it wasn't specifically prohibited by federal law, pharmacist must not list the name of the prescriber on the fulfilled medication for gender affirming healthcare services or reproductive healthcare services, but would instead list the name of the facility where the practitioner is employed. After some additional work and discussion by some of the stakeholders, including the pharmacy community, there were some concerns about how to operationalize that. And so the revised version would say, upon request of a prescribing practitioner and to the extent not expressly required as opposed to prohibited, because of better workplace under federal law. And then this would have a pharmacist or other licensed member of the pharmacy staff must redact or otherwise remove the practitioner's name or initials from a fulfilled prescription for a non-controlled, so medication that is not a controlled substance. We don't have authority to dictate what's on the label for a controlled substance. The feds dictate that. So for a non-controlled medication or gender affirming healthcare services or reproductive healthcare services, and from any accompanying printed materials. The provider requests, the pharmacist has to redact or remove the prescriber's name from the bottle or other container of medication and from any accompanying paperwork. Might be scribbled in the front of the bag or otherwise going with it. Similar language is added in 2 and 3. 2 allows the pharmacist to remove their own, remove their own name or initials, or if the pharmacist requests another member of their staff would redact or remove their name or initials from, again, a non-controlled medication and accompanying printed materials. And then number 3, if a prescribing practitioner dispenses medication directly to patients, then the practitioner can redact or otherwise remove their own name. And it allows subsection C, specifies that it's okay for the pharmacist to do this. Subsection D is really, I think, why in particular you're looking at this. This provides immunity from civil and administrative liability if a pharmacist or other member of their staff fails to redact or remove the name of a prescriber or pharmacist when requested to do so, provided, however, the immunity does not apply to gross negligence, recklessness, or intentional misconduct by a pharmacist or their staff. So there's ordinary negligence. There's some concern from the pharmacists about what this will look like in practice and how easy it might be for them with different e-prescribing technologies and other ways that prescriptions come in, how easy it might be for them to miss a request and concern about there being civil or administrative liability if it was just ordinary negligence, but not providing that immunity to higher levels of misconduct.
But that negligence would have to cause harm in some way to the person who receives that medication.
For them to, yes, for them to succeed, not to the person who received the medication, but to the prescriber. It's really about the prescriber or pharmacist who you didn't want their name on the packaging. If there was some harm that came to the pharmacist or prescriber as a result of that request for redaction or removal not being followed.
I'm confused. How must be missing something. So how is it that they would be immune from liability if they harm themselves?
No, it's more so we'll take the pharmacist's name out of it. So if the prescriber says, please take my name off this pill bottle before you give it to my patient.
Like the doctor, okay.
Right. And then the pharmacist misses that request and the bottle goes out with the doctor's name on it. And the patient brings the medication to another state and there's action taken, or that state is seeking to take action against the Vermont prescriber. Prescriber's name shouldn't have, because they found the bottle. And there's harm to the Vermont physician as a result.
Got it. Makes more sense now.
No, I haven't to say, I also got caught in a circle of like, wait a minute, what?
I think I was conflating pharmacist and prescriber. at the same
Yes,
time.
prescriber is like in most cases, is the doctor. There's pharmacy prescribing that is outside of the context of this.
Is that a hand? So no,
It's just in the extension, it's a finger, but it's the finger attached to my hand. So what we're saying is by simply removing the doctor's name in specific case, there's no way to retrieve this. There's no record of this. There's no pharmaceutical number on this, which is going to attach somebody's name to this prescription in this one.
So that is still, I mean, in the pharmacy system, it is still there. The prescriber's name is there. If anything bad happens with the patient, then they need to be able to identify the prescriber. That information is still available. It's just not literally on the materials that are leaving the pharmacy with the patient.
Okay.
Thank you.
Anything further? Committee? Anything further from you folks? Okay. Well, guess I should ask committee, are there any thoughts on this, concerns, those changes that we want to discuss?
The additions make sense, okay?
Okay, great. Thank you for coming in, especially on short notice. Appreciate it. We're